Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, a lot of you have been waiting on pins and needles about the ruling on the temporary injunction in the matter of Bruen v. Ferguson, which is one of the two suits here in Washington State to overturn RCW 9.41.370 or magazine ban. We've spent a lot of time talking about that because we've been waiting and waiting and waiting for a ruling on that temporary injunction. In the meantime, let us not forget that there is another lawsuit, one that was actually filed earlier here in the Western District of Washington to challenge the exact same law, and that is the matter of Sullivan v. Ferguson. Well, there has been some developments, a small win, but a win nonetheless. And you know, in order to win wars, you have to win certain battles along the way. And this might be an important one. And it might be an important one because I think that everyone around the country needs to pay careful attention to what happened here. So today, let's spend a few minutes and get you all up to speed on a small but important win in the suit to overturn Washington's magazine ban. Okay, so the issue we're talking about today is the case of Sullivan v. Ferguson. Now, we have already done a couple of videos on Sullivan v. Ferguson, including this one right here, where we interviewed the chief plaintiff's counsel, that's Joel Ard, right here from the state of Washington, and Mr. Ard got us all up to speed on everything that had been occurring in that case, and obviously, I think all of us could tell that Miss Sullivan was in incredibly good hands with plaintiff counsel, Mr. Ard. Now, as that lawsuit has been kicking around and ricocheting, along comes the Bruen opinion, and now, of course, everyone is focusing on historical analog. And, of course, the reason that we are now suddenly so interested in historical analog in the post-Bruen world, essentially, if the legislation that is being challenged covers activity, which is covered by the text of the Second Amendment, it is presumed to be unconstitutional and will only be deemed constitutional if the government can find a relatively equivalent historical analog that shows that we as a country have accepted that type of firearm regulation in the past, going all the way back to the formation of the country and the adoption and ratification of the Second Amendment. Absent that, then that legislation is unconstitutional. Now, what the court, and this is the Judge David Estudillo in the Western District of Washington, so his honor, had suggested at one point, just last week as a matter of fact, that perhaps the court should hire a historian as an expert witness to come in and explain the rich history of gun control regulations in the United States. Now, both sides were given an opportunity to weigh in, and shockingly, the state of Washington was all for it. And the reason they were probably all for it is you can imagine how easily it is to put your thumb on the scale by getting a certain expert appointed. Don't believe me? Then take a look at what we talked about in this video with Colonel Craig Tucker, formerly of the United States Marine Corps, and some of the outlandish and outrageous testimony that he provided as to the ballistics behind the AR-15. And so late last week, the court entered what's called a minute order, which is basically, hey, I'm going to notify the parties of what I have decided. And the court has decided, and this is good news, this is the win, is that we will not need a historian in this particular case to help the court understand the history of the Second Amendment. One does think that perhaps a federal judge should understand that. The court's ruling specifically stated, the court, having reviewed the parties' response to the order to show cause, determines that appointing an expert witness pursuant to Federal Rule of Evidence 706 to assist the court is not necessary at this time. The court reserves the right to appoint a court-appointed expert in the event it seeks further clarification of the evidence and testimony put forward by the parties' experts. The court appreciates the concerns raised by several of the parties as to the appropriateness of utilizing court-appointed experts in the Bruen context, as well as the practical difficulty of finding such an expert. Well, the good news for Judge Estudillo is that expert has already existed. Now, unfortunately, he is now deceased, but that expert was Justice Scalia. Because if we go back and we take a look at the long, and I do mean long, historical analysis that Justice Scalia went through in District of Columbia v. Heller, and go through the long analysis of every single type of gun control legislation that was ever permitted in the United States, we know from all of that historical analysis where we sit today. And where we sit today is a very simple rule called the common use test. And the common use test essentially says that firearms, which are currently in circulation today, popular types of firearms, cannot be banned. As a matter of fact, what the common use test really says is that the only historical analog that we can find anywhere in our rich history of legislation on this topic is that we have permitted the regulation of firearms which are both dangerous and unusual. Now, many on the gun-grabbing left believe the test is dangerous or unusual, including this Illinois judge right here in this video right here. But no, the test is, in fact, dangerous and unusual. And Judge Estudillo's ruling here in the Sullivan case is consistent with how the court should conduct its business. Let us not forget that despite the fact that the Heller opinion is well over 100 pages, and there are dozens and dozens and dozens of pages spent on the historical analysis, Justice Scalia nor any other justice of the court employed a historian to do that. There was no historian needed in the McDonald case. There was no historian needed in the Catano case. And most recently, Justice Thomas did not need the assistance of any historian to come to very clear rulings in the Bruen case. And at the end of the day, isn't all courts' roles, when you think about it, to go back and take a look at history? If you're a trial court, you are reviewing evidence which happened in the past. Therefore, you are assessing someone's version of history. If you're at the appellate level, it's even more straightforward in its application. You are taking facts which exist today and applying them to laws and case law which came from previous to the enactment of these laws or the occurrence of these events. Everything in the law, whether you're doing contract law, you're going to take a look at what happened at the formation of the contract. If you're doing tort law, you're going to take a look at what happened during the occurrence of that particular tort. If you're doing criminal law, you're taking a look at what happened in the past in the way of criminal conduct. All law is based on history. And of course, this sets a very dangerous precedent, because what happens the next time we have a major civil rights issue related to voting rights? Do we need to bring in a historian then to kind of help the court understand what our history of voting rights is in this country? Or what happens when we have a significant free speech issue before any type of appellate court? Do we suddenly need to bring in experts to help the court understand what the history of the First Amendment is? Because if we're having to bring historians in for the court to understand the history of statutes or constitutional provisions, why then are they wearing the black robe? And so going full circle all the way back to Judge Estudillo, Judge, yes, you made the correct ruling, and more importantly, all the historical analysis that you need to do has already been done for you by a Supreme Court justice. It's all found in the Heller opinion, and it really is simple as this, because what we're talking about here is a ban of magazines. We're not talking about some other type of limitation. We are talking about an outright ban of standard capacity magazines associated with most of the most commonly used firearms anywhere in the country. And when we're talking about outright bans, as what we're talking about here, then we get into the common use test. And if these magazines are dangerous and unusual, then and only then can government restrict them. And since they are neither dangerous and they are certainly not unusual, RCW 9.41.370, the standard capacity magazine ban passed in Washington State through engrossed Senate Bill 5078, is in fact on its face unconstitutional. Okay, so once again, the case is Sullivan v. Ferguson. We've geeked out on this case before, and I'm getting an idea that we're probably going to need to contact Joel Ard, see if we can get him back on the channel and get some updates on that case. Remember, we got another case kicking around in the Eastern District of Washington. That is Brumback v. Ferguson. Our good friends at the Silent Majority Foundation are bringing that one. Obviously, if we ever get a ruling from that court, you will be the first to know. In the meantime, if you got any questions about Washington's magazine ban or what's left of our Second Amendment rights, you guys should know the drill by now. You can always contact us at WashingtonGunLaw.com, or you can call us directly at 425-765-0487. Now, in the meantime, let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.